Mr. Original Sheriff Tom's warrant. A motion to quash has been submitted against it. The cause number is sequence 259443. The motion to quash is made on 3 points, and Mr. Tom is represented by counsel from the Judge Advocate General's Corps for the National Guard. I'd like appearances made there as well. Miss Lieutenant Boppy from the JAG Corps and Major Pancakes. And also for the state, who have compelled appearance, is Deputy Attorney General Derogatory, is that correct?
Yes, John.
I have a transcriber, Slippery 27, from the court who would be happy to transcribe and record these proceedings. So if there are any concerns as to the record, we also have about 34 other people witnessing this. So I think we will not have any issues when we need to correct anything or clarify something here. I have been keeping track of the events leading up to this motion, to the warrant themselves, and to some of the recent news articles as well. And I have some strong concerns regarding all of them, and I'd like to raise those all with you here today in light of the warrant. I won't delay much longer with the bluff. I'd like to have Mr. Tom's counsel speaking here very shortly. If you don't mind, you may present your arguments.
Thank you, Your Honor. Major Pancakes, Judge Advocate of the General's Corps, Deputy Staff Judge Advocate. I'm joined by Lieutenant Botfi. She's going to provide the foregoing, most of the primary arguments, and then I will supplement as needed any additional comments that we have. We really welcome any interjections you may have, any questions. We want to make sure everything is entirely clarified for the court record and just for your general knowledge. So without anything else, I'm going to turn it over to my lieutenant.
Okay, that's fine. Thank you. Thank you, Major.
Thank you, Your Honor. So we are moving to quash the arrest warrant issued on March 31st on the original Tom Sheriff. Firstly, arrest warrants, per the rules, can only be issued in 2 circumstances. One, where exigent circumstances exist and the person has left the immediate presence of law enforcement officers, which is also known as LTAing here. Secondly, when there are criminal information filed against the person with the arrest warrant. Your Honor, here there are no exigent circumstances. The affidavit, I don't know if you reviewed that, and it's just clear that this is from a good couple of days ago. I believe it has been 3 days that have passed since the incident has happened. And in the video that was uploaded with the affidavit, we see that the original Tom Sheriff was immediately, quote unquote, neutralized after the alleged allegations had happened. And so there is no concern here for public safety. The original Sheriff Tom has not done anything similar. He has not abused his position as a guardman. There have no been other incidents in line with the allegations against him. And secondly, he did not evade or avoid arrest in any circumstances. He, again, was neutralized, and there had been no attempts to arrest him in game. And then, do you have any questions, or would you like me to move on?
Oh, no, just please go ahead. I'll just hear your whole argument here, and then I'll raise some questions after that.
Yes, absolutely. Yes. Tactical, did you want to address the jurisdiction, or would you like me to continue on?
Yeah, I'm gonna touch on mainly some statutory considerations for the court to consider. One, which I would argue more than likely LCPD did so not maliciously in error, just in error, not just generally lacking knowledge on this subject. We highlighted it in prong number 3 of our motion to quash. I'm going to read the statutes verbatim, quote unquote, left out. But basically, Lander City Police Department has, under Title IV of the state code, a jurisdiction that is prescribed to be within the city of Lander. And that is commonly known. That municipality is well established. We're not going to litigate the semantics of that. And then obviously going forth in the affidavit submitted by a member of the Lander City Police Department, obviously Fort Standish is not within the confines of the city of Lander. And so that raises the question, does a city police officer with the Lander Police Department have jurisdiction to file a filing before this court in support of, in this case, it's essentially a criminal information for lack of argument's sake, before court for actions taken outside of their jurisdiction? The common response would be, well, they are state certified officers, they have statewide jurisdiction. That is wrong. They are empowered to be employed as law enforcement officers throughout the state of Mayflower. They are not, however, given the jurisdiction statewide. And then, as we note, 4 MSC 5 1401, law enforcement are bound by provisions of the state code that stipulate restrictions. So in 1102, obviously their restrictions are the confines of the city of Lander, so they must abide by that jurisdiction. And then see also, as we note in the motion 1402, the following: if a law enforcement agency is established to serve a particular subdivision, the respective department head is responsible for ensuring that their law enforcement agency's policies maintain peace officers in areas in or around the political subdivision. This is incredibly clear, black and white. I don't think there's much room to litigate this matter in terms of that. The affiant in this case is a senior detective with Lander City Police Department. The fact that they were outside of their jurisdiction, whether they want to argue anything in regards to that, is not relevant, because they were not requested to be there, nor did they necessarily have permission. They were not involved in the activities that were taking place at Fort Standish. But irregardless, even if the court wants to suppose that they had every legal right to be there, they lacked jurisdiction to then file, in this case, an affidavit in support of criminal allegations against a member of the National Guard. It happened outside of their purview. And given the fact that the state code restricts that purview, it would not have therefore been proper for the district court in this matter to have taken the affidavit at face value and issued a warrant for actions taking place outside of their jurisdiction. I would argue that irregardless of the factual aspects of this case, which I think clearly show that they did not support the charges filed, irregardless of that, obviously if a TCSO deputy or if an MSP officer or anything falling into an appropriate category, a military police officer, that is not the case. This affidavit was not filed by them, so it is improper in form and improper in legality. And then obviously we touched on the procedural aspect. The second prong deals with what we believe to be a potential conflict of interest with the court. I would offer that we table that issue if we want to digest the first and the third arguments, which are the primary legal arguments.
Yes, I would agree with you on that. It seems it's a very loaded set of points you've raised there, so I'd like to tackle those a bit carefully and in pieces, if possible.
Correct. Yeah, I figured as much, so I wanted to just make sure we kept it as compartmentalized as possible.
Yes, that's fine.
But that is our primary arguments, and again, we welcome any dialogue between the court and us if you have any questions.
Yes. I think my first set of questions rely on, and I don't know whether you'll be answering this question at all, if you will be refusing to or not. It may touch on a more sensitive subject, but I'd like to know how you've obtained the affidavit in order to file this motion, because I have not released this to anyone. No one has particularly obtained it through discovery. I have received requests, but they still are being processed. They have not come to my desk thus far, and I'm not aware of anyone who might have released it to the wider public or anything along those lines. I just kind of want to know where you might have particularly obtained this affidavit, because you've made a reference.
I'm sure
to...
I can get you. I can confer with some counsel on that. What I would say is, while I am not, and I don't believe my co-counsel is 100% sure how he received it, I guess my point would be, unless this case was ordered under seal, which to my knowledge it was not ordered under seal, I don't believe there's any statutory violation for us coming into contact with the affidavit. We are empowered, as the court is obviously aware, we are empowered to file this motion to quash, and I think the essential element in order for us to base a motion to quash would be the facts and the stipulations made by whomever is acting on behalf of the state to move for these charges. So I don't think there is a matter of law that is at issue when it comes to the possession of the affidavit, unless the court had issued an order to seal it. I am not aware of it, and I don't see any record of that on a Trello card. But again, I can try better to find out. I am not aware of exactly how we received it. I am conferring with counsel right now.
That's fine, because I just like to mention that we usually never release the affidavits until they have been executed, otherwise make them available for release after the warrants have been executed and served on the person who the warrant is actually targeting. In most cases, we would not expect these affidavits to be released until they have been requested to be released and that request has been granted. And a copy would have been given by the court so that it would enable defense to formulate the motion. So I'd like to know as to what manner in which this was released, and I fear for the worst that there would have been an improper disclosure, which may or may not bring some level of liability, but if you need time to figure this out, I'm more than happy to touch on it later anyway and get to the main arguments.
Yeah, we are absolutely committed to. We will find that out for you. I'll just reiterate, I don't believe that a procedural or statutory violation occurred in us receiving it. I believe it was actually voluntarily given to us, but I can find out the chain of custody, if you will, as to how we received it. But again, kind of as you hinted at, the legal arguments remain entirely intact, because this document is 100% binding as it relates to the arguments made. So I will get back to you on that.
Okay.
Yeah.
That's fine. We'll come back to that later then. I'd just like to touch on the issues of jurisdiction. You make it very clear that the Lander City Police Department in this case was not essentially permitted, so I want to put it lightly and simply, to really file this affidavit by way of them not having jurisdiction to actually enforce a particular set of laws or whatnot, and that they would not be able to effectuate an arrest or really do any of their law enforcement job because they are out of jurisdiction. And you do make the mention about them, about the particular provision, I think, where it says that they have state, that they would have powers to enforce the laws across the state, if I'm correct. I'm just trying to find the particular citation you made. What was the citation that you've
Sure, yeah.
used?
So Title 4 covers a multitude of different things. One of them obviously being the powers of law enforcement. We don't dispute that state certified officers can be employed anywhere in the state as law enforcement officers. What we do note is that both in statutory language and in common law, it is well established that law enforcement officers have established jurisdictions. In this case, the state code that would be 4 MSC 8, or excuse me, 4 MSC 5 1401 is the statute that requires law enforcement agencies act within any statutory restrictions as it relates to jurisdiction. And then 4 MSC 8 1102 is the statute which limits the jurisdiction of the City of Lander Police Department to the municipality of Lander. And so our offer to the court is that, yes, every member that is certified by the Law Enforcement Training Institute is capable of being employed statewide. But when it comes to the location that they are employed, they are bound by statute and by policy as to when they can exercise their law enforcement authority and where that authority ends. And so in this case, sorry, yeah, go ahead.
No, because I just wanted to mention that would the jurisdiction be strictly limited by land boundaries, or would jurisdiction also be extended if, say, a particular officer from that force were physically harmed, killed, or otherwise something happened to them and it still happened outside the jurisdiction? Would the system, well, would state law still permit for the I can't really put it in a better way. I think I'll put it simply like this: if the LPD cops were to be killed by harm, would LPD still, under state law, would there be something to afford in the state law that LPD could somewhat be involved in the investigation, otherwise the enforcement of the law against perpetrators for something that happened on, I guess, military grounds? Would there be any limitation of it whatsoever? If
I appreciate your question, Your Honor, and it is a good question. I guess my first thing I would point out is that the state code doesn't necessarily grant the court the leeway to kind of evaluate merits as to when it would be okay for the LCPD in this case to disregard the boundaries of their jurisdiction. Now, that's not to say that there might not be a policy in place. But again, the state code is incredibly clear that their jurisdiction ends at the limits of the City of Lander. And so while there could be
I'll ask where that is specifically under state law.
Correct. That would be...
Where is it?
Sorry, I'm a lot of numbers.
No,
4 MSC 8 1102 stipulates that the Lander City Police Department jurisdiction, quote, resides within the City of Lander, unquote. And again, I would only assume that is mirrored in the policies of the Lander City Police Department. I'm not a privy to their policies, but they are bound by the state code to follow that provision. So again, I guess also turning back to answer your question when it comes to an exigent circumstance, which essentially is what you're referring to, or possibly a request for assistance or urgent need for help.
Generally, yes.
Generally?
Yeah, generally, yes. That's what I was making a reference to. I don't know why I went on a long-winded there. I'm so sorry about that.
No. Yeah, I totally understand. Again, our response being that in this case, if you want to evaluate it from that lens, number one, I don't see where the court is given the leeway to evaluate it under that lens, because the state code doesn't say resides within the City of Lander unless X, Y, or Z potentially happens. So that's my first argument to your question. My second point would also be that even if the state code gave you the leeway, which it does not, that would be a question for evaluation, I would believe, if this case were docketed in a criminal matter. I don't believe that in this instance, the question for a motion to quash really stems from the jurisdiction as it relates to the questions and the facts presented. And so in the questions and the facts presented, there is no allegation that these officers were responding to some urgent need for help. Their lights were not on, their sirens were not activated when they were on base. There was no indication from them via the radio or any other indication that they were responding under this type of circumstance. And I also don't believe there is any factual allegations to support that claim. And so for that reason, I don't think the court could look at it through that lens, because those facts are simply not admitted in the case as it currently stands. But again, I think we're getting the cart before the horse here, because the state code preempts any kind of investigation into such factual stipulations. Is simply not a relevant aspect to this motion to quash. We have to. This court would need to evaluate it as the factual allegations exist, not otherwise.
I do understand this, but I have to go back to your your 4 MSC 1102 argument there. I've had a read of the actual language, and I feel that in some way it might be misrepresented. I will read the text here for you, and for everyone's
I believe
benefit.
I know what you're referring to. It's the Capital Act, I believe, is the short term name for it.
Can I please read it?
Yeah, absolutely. I was just acknowledging
Thank
that.
you.
I think I know what you're talking about.
I understand, but I'd just like to read this out. That it says, for the purposes of this chapter, being this particular act, the Protect the Capital Act, the term Landersea Police Department shall refer to the municipal law enforcement agency whose jurisdiction resides within the city of Lander. Are you saying that just by that alone, somehow that confers a restriction under the other law that you've cited, which mentions about the
Absolutely.
powers being restricted? How?
Yeah, absolutely. I was prepared to answer this. So the statutory language under 1401, which is the statute that talks about the restrictions, it doesn't say only if they fall under a certain category of the state code, or only if they fall under a statute that is designed specifically for restriction. The text of the statute says are bound by provisions of the state code that stipulate restrictions. It doesn't say restrictions under perfect examples of a state code or an act which explicitly outline them as restrictions. It simply says restrictions. So again, going back to a previous argument, I don't believe the court is empowered to find issue with the fact that the state code, regardless of the location of the statute very clearly states that the jurisdiction of the
I think that's a very big misrepresentation there. We still have jurisdiction to review these kinds of issues, whether anyone really likes it or not.
I agree that you have jurisdiction to review it. My argument being that the state code does not permit words to be added to it, if that makes sense to the court.
I don't understand what you're trying to say there. That's very confusing. Please, can you elaborate?
Yeah. So you're, like, for example, you offered the hypothetical regarding a request for assistance or a request for help, which is not an issue that is addressed by the state code, nor is there leeway given for it to be addressed. And so in similar form, I believe the court takes issue with the location that the statute resides within our state code, which I can see in some cases it may be confusing for someone who has either not read the state code before, or to a lay person it would make sense that potentially it does not apply.
I'm sorry, I take great offense to that. I would not want to undermine the knowledge and the depth of knowledge and the understanding that other police officers may have about their own roles. Could we refrain from making any comments about their character, insofar as to their knowledge and to their capacity to understand? I think that's very well, rude.
Absolutely, Your Honor. I think the general consensus, which is true, is that 90% of law enforcement officers are not licensed attorneys in the state of Mayflower. And the only supposition I was making was that, obviously most people, and I think most officers, have not read the entirety of the state code, was the only, but I 100% take your point, and I'll make sure to kind of tailor my remarks a little bit more, not so as not to potentially offend the feelings of law enforcement, because I would not want to do so.
Well, I understand. I think we'll move on from that point. Just wanted to make that point across, because I thought it was a very inappropriate thing to say in open court, where some are also members of the force. I just like to hone on the fact that your characterization of 1102 seems very, very far-fetched for me. I don't see how this would this particular provision somehow is considered a restriction. under, oh god, I keep missing the citation for that. I'm too old sometimes, Forgive me. Just give me one moment here. I'd like to pull up the particular law that you've cited. What was it?
So just to clarify,
1401, 514.
Correct, 1401.
Yes. Yeah. So I don't see how the 1102 section can somehow be a restriction for the purposes of 1401. It seems very far-fetched considering its definition is used explicitly for that chapter, and that construction that you've made between 41 and 1102 seems very, for lack of a better word, and I do apologize, flimsy.
All right, so just to clarify the court's position on this, does the court deny that 1101 states that the jurisdiction of the Lander City Police Department is the confines of the city of Lander? Is that an issue?
Well, that's not what I meant, is that your reference to 1102 may not be the restriction that 1401 requires. Is my microphone working? Yes. Sorry, I thought my microphone wasn't working. It may not be, for the purpose of 1401, really that particular restriction. I don't know if there's a better example in the state law where generally states that LPD's jurisdiction is restricted solely to the city of Lander, and whether there is in fact any, because you also mention about the land border thing a lot. If I'm correct, there is a lot of argument to be made about how the jurisdiction ends at a specific point. Is there a better example other than 1102 where it shows that the jurisdiction is definitely to be in the city of Lander, and that the jurisdiction is fully and readily defined in terms of the land borders? Because if I don't see that, I think it's going to be quite hard to really argue your point. But yeah, I'm open to anything.
And so I'll answer this in two parts. First, I'll address the statutory thing, and I'm going to pivot back to asking us a second question of the court. But primarily, my response would be respectfully, with the utmost of respect to the court. I don't think the court has the purview to select or choose where the best parts of the state code are to be enforced, and I don't think that's necessarily.
I'm not trying to choose what parts of law to apply here. In particular, I am considering wholly, but I'm wondering whether there's a better example than 1102 for this court to refer to. Because if this is the best example, I don't know. That's just kind of my initial belief.
Unfortunately, we are bound by the fact that we have a Congress made up of high schoolers and college level students. Our state codes, our acts are not.
Mr. Pancakes, we cannot make
what?
Such comments here. I understand that you have.
It's a fact, Your Honor.
I understand, but we should refrain from making such comments. I would like it if we had done that, but I understand where you're coming from. But I will, for my
essentially
own purposes,
my point being that we are limited by the fact that this game we play, its laws, the structure of our government is limited insofar as the bounds that are done by members of Congress to establish our state codes. And so it's times, and there's many examples of this. Title V is a perfect example. Where we just have limitations on our statutory assertions and laws, simply because of the fact that we play a game, and this is not the real world. But my point being that no, we cannot cite a perfect code which says here is the exact jurisdiction of the Lander City Police Department. You can do such in cases like the state police or the Clark County Sheriff's Office, because they have been properly set up in the state law. But in this matter, the only statutory language we have to go off of is 1101. Does that make it insufficient? I would argue no. And I don't think the court, while I completely understand where you're coming from, I too did not appreciate the fact that they just threw this jurisdiction into a random aspect of our state code. But it is an active and binding code that must be adhered to by this court, regardless of its location in our state code. I mean, if 1101, for all intents and purposes, happen to be placed in the middle of the State Transportation Act, for example. Regardless of how out of place it might have been, it doesn't negate the fact that it is an enforceable statute in the state of Michigan.
I disagree. I think context very much matters when you do statutory interpretations of any kind. Context is absolutely important in that respect. A good chunk of statutory interpretation relies on the fact that there might be some context to work with. Where in absence of it, they're very difficult, and some of the interpretation may not be safe as a result of it. But I think context is very important where it is available, and I think it is a big factor to account for. I think that's what you may be trying to attack against or whatnot. But for lack of a better word, please, I'm using the most polite word I could possibly find. That I make my point very clear, and that
yeah, I'll take it, and I'll concede the fact that this is put in a confusing place. Our in totality, our argument being that there just simply is not, in our mind, a legal reason to necessarily disregard the
Mr. Derogatory. I will hold you in contempt if you yawn again.
Oh, my bad.
Please.
Yeah.
If you're not gonna say anything, please turn your microphone off.
Oh, you got it.
Oh, days.
Right. Your Honor, so just so we don't get bogged down on this one element, I'm going to pivot back real quick and just ask the court, does the court stipulate to our procedural, the procedural element of our motion to quash in regards to the lack of sufficiency as to the rules of procedure that were violated when this warrant was issued?
Are you talking about point 1?
Correct. Yeah, I figured at this point, so we don't get bogged down, it might just be easier to go. Because if we satisfy the first prong of our motion, then there's really no reason to continue to litigate the finer details. Because if you find that there was a procedural deficiency, then the review stops there, and we would very much so be entitled to quash the warrant.
Well, I would agree with you on that if there was a procedural concern, but I would have found that anyway. But insofar as the warrant goes, I have not seen that. I just like to just come back just a moment before we go to that. To go to your first point, I have to take note of the fact that you keep repeating that the court does not have purview jurisdiction or whatever as to decide the issue about the jurisdiction of LPD or otherwise be able to interpret it correctly or whatnot. We do. We've always had this. I'm not sure what you are trying to say with that. It concerns me strongly, and I'm not sure whether I should interpret that as you saying that we do not have jurisdiction, or that you do not recognize the jurisdiction of the court, which would be a very bad comment to make in open court.
Would you, Your Honor, allow me to clarify just so the record is entirely
Yes, please.
clear?
I'd like to. Yes.
I believe what I have said, I believe this is reflected in the record, but again, I can entirely concede if this was misconstrued. Our supposition, the supposition of the Judge Advocate General Court, is that the state code that we're referencing, 1101, explicitly states that there is a jurisdiction for the Lander City Police Department, and that such jurisdiction, unequivocally, without question, per the text, exists within the confines of the municipality of the city of Lander. And this is not a novel legal argument. For example, the very mission statement of the Lander City Police Department is, quote, acts as the municipal level civilian law enforcement agency of the city of Lander. And so I guess the point we're making to the court is that while, yes, this is the review process, the court is 100% empowered to review our motion, its elements of the motion, and the legal arguments, etc. Our argument is that the language of the statute is unequivocally clear, and that was the point we were making to the court. We were not trying to stipulate that there is some lack of authority for this court to commit judicial review. And if there is any question about whether or not Lander City Police Department is a municipal law enforcement agency, again, state code under Title IV, the same title we've been discussing, Title III, in fact, does define Title III, 2103, does list Lander City Police Department as a municipal law enforcement agency, just for record's sake. But that was the point we were making, is that this court, yes, can review the matter and the arguments contained therein, but that the statutory language is completely and unquestionably clear.
Would the political subdivision in question, because you make reference to 2103 just now, would it necessarily require that a particular city government has to be established and that it is in full fact and force, and that its authority has been delegated under the Home Rule?
As a matter of law, Your Honor, is that a question or were you just opining?
I'm asking a question. Does the law require that for a political subdivision to exist, or let alone something to be considered a political subdivision, that there be a functional government for that particular
That's a
political
great question.
subdivision?
My co-counsel, I believe, is double checking that now. I have read the entirety of the state code, and
you haven't prepared this argument? I thought this. You mentioned 2103, and I thought you would have had this prepared in advance. This would have been a question expected.
I'm just going to read 2202, just a ways down from 2103. Quote, a municipal law enforcement agency shall employ no more than 120 employees if their jurisdiction resides within the city of Lander. The jurisdiction of the aforementioned agency resides within the city of Lander or any otherwise incorporated municipality where the Senate chooses to convene.
I don't consider 2202 AI. That's repealed. That's the language that I cannot factor in.
Correct. I was continuing to read on, but again, in answer to your exact question, oh, perfect. My counsel found it. So Title 3, MSC 1, 2103A, quote, the term municipal law enforcement agency shall refer to, quote, any government agency within the jurisdiction of a municipal political subdivision that enforces the law. In response to your question about a political subdivision, we cannot find a specific statutory definition of a political subdivision. What we can say is that what is repeated throughout the state code, disregard one more time, my counsel found additional information. 3 MSC 1 6101 subparagraph A. The term political subdivision shall refer to, quote, regional jurisdictions generally include but are not limited to the state, county, or municipal governments residing within the boundaries of the state of Mayflower. So I think there is a clear statutory language and vision that is painted for the court. If they want to say, for example, why then wasn't 1101, the statute regarding a jurisdiction for Lander, why wasn't it in a special section for an act regarding the city of Lander? Well, for one, there is no Lander city government, but a political subdivision does exist. It is the city of Lander. The court, I mean, this is common law knowledge. This is well established that the city of Lander does exist. Otherwise, why does the Lander City Police Department exist?
The city of Lander government exists?
I said the city of Lander Police Department does not exist. I said, but the very fact
wait, I'm sorry. I misunderstood completely. I think I lost my train. I lost my trail here, because you've just said that the city of Lander Police Department does not exist. I think you might have I don't think you were trying to actually say that.
I said, so the city of Lander, as it relates to a government entity, you referred to why then would we interpret 1101 without there being an actual political subdivision, i.e. a city government. There is no current Lander city government. That is by design of game administration, something we cannot litigate. What I will say is that the fact of the matter is that there is a municipality defined as the confines of the city of Lander. The city of Lander does in fact exist. This is well established law. I won't insult the court's intelligence by trying to argue that. The court obviously accepts that the city of Lander exists. And by default, the Lander City Police Department also exists, and that is a matter of statutory and well-established law in the state of Mayflower. So those two elements are 100% present. For one to argue as it relates to a political subdivision or a municipality, well, the city of Lander is considered by law a municipality, and the Lander City Police Department is considered a municipal police department. I think the overwhelming statutory language, regardless of how or where it is located in the state code, it is concisely establishes and creates the understanding that the city of Lander exists and that there is a definite jurisdiction of the city of Lander. But again, we've spent a significant amount of time, so I don't want to waste the court's time. So
I get to determine whether we touch on a particular issue or not, and I understand that we are particularly strained for time. But if we have to drag on for however much time we want to, then I will do it, because these are all very important issues, and I like to make sure that I am firm in any decision I make for this particular issue. I know it's very sensitive, it has a lot of attention by the media, among other things, so I'd like to be absolutely certain that decisions I make here will be sufficient enough for the scrutiny from this court and from other courts, and also by other legal experts. But I'd just like to make it very... I just like to ask, in particular, if the City of Lander Police Department does exist, are we just assuming that the City of Lander government exists, even though they have not physically been formed? No physical formation of it has been made. There is even no written law in particular that would grant the city government any particular powers thus far to govern itself or anything like that. There is absolutely nothing I can see where the city government does actually exist in any form other than references to it in state law. And in that case, would it not be fair to say that if that city government does not exist, their authority kind of really stems from the state? And in that case, the jurisdiction argument that you raised may be fakey, to put it politely, because I'm going to bring your attention to that. Could be a potential scenario, and I'd like to hear some reassurances that I'm wrong or anything along those lines. If you want to clarify, I'm more than happy to. Mr. Pancakes? Hello? Did something happen? Mr. Oh, hi. I'm not sure what happened to Mr. Pancakes here.
Maybe it was too much for him.
Yeah.
The government would like to say something about jurisdiction.
For the time being, I'd like to try and maybe get Miss Boppy to fill in. I know it might be a little bit inappropriate, just like to make sure that we kind of touch on some other points. Mr. Dorgacher, would you mind if I asked Miss Boppy to maybe speak?
Oh, no, Your Honor. Go ahead.
Okay, thank you. Miss Boppy? Or Lieutenant Boppy, sorry.
Yes, Your Honor.
Would you like to perhaps talk about point 1 while Mr. Pancakes is recovering from some technical issues? I think we are aware that he probably does have a technical issue right now. So.
Yes, absolutely. I was just in contact with him. He is trying to reconnect, but I will absolutely address point number 1. So in point number 1, Your Honor, we focus primarily on the rules of criminal procedure. And it, like I said in the opening, it really outlines very few circumstances where arrest warrants can be or should be issued by a court. And we obviously are on the belief that none of these circumstances exist here for the issuance of this arrest warrant. And quite frankly, arrest warrants do have these sort of boundaries to them because they aren't tools that should be used to kind of circumvent the power of the Department of Justice to choose whether or not to prosecute somebody.
So you're saying that the arrest warrant is an instrument against the state's own power to prosecute? That seems really weird to me. You know why? Because arrest warrants are usually filed by, people who are working for the government, who are enforcing the laws, and if this somehow is used as an instrument against the enforcers of the law, does that make any sense to you? I don't. It's hard for me to even say it. This sounds bizarre to me, what you've just said. That the police filing an affidavit to get an arrest warrant that somehow contradicts the interest of the state to prosecute. Does that make any sense to you at all? Does that sound right to you? Because I don't think that sounds right to me at all. Because whenever people file affidavits, they usually cooperate with the prosecutors. Otherwise, prosecutors decide, after the warrant's been served or what have you, even before then, they'll have some level of involvement, some review as to the way that the police have handled it, or the charges themselves, the nature of them, and the events surrounding them, and they'll usually litigate it sometime later into the process, not now. I'm struggling to understand what you've just said there. You're also representing Mr. Tom, who's affected by this. You're not speaking for the government, are you?
No, we are representing Tom.
Right.
Yes. So I'm not going to speak behalf on the government. The government is here and can talk themselves. I was just commenting on the controversy that you had mentioned that can't really be ignored in this case. But nonetheless, even kind of absent that, this warrant still does not comply with Rule 2 of the criminal procedure because, again, there were no exigent circumstances present. There is no risk to public safety. There is no risk to evidence. There is no now or never situation, especially since this was filed 3 days after the incident actually occurred. And again, there's no LTA. There is no evasion of law enforcement. So that gets rid of already one of the requirements to getting an arrest warrant. And second of all, the Department of Justice, as we have been tracking, has not filed any criminal information or filed anything in a court that would justify getting an arrest warrant on Tom.
Do they have to file an information in order to be able to action a warrant? Could officers not file affidavits, seek a warrant, get the warrant, and then the DOJ can still determine the situation after the warrant's been served at a later time? Could they not do that? Is it not available to police officers to ask the courts to get a particular warrant issued against a person because they committed a crime or whatnot, or otherwise suspected of committing a crime? Is it not? Wait, is that what you're trying to say? I don't understand this at all.
Your Honor,
I'm very confused.
Yes, I'm quoting directly from Rule 2, and Rule 2 very plainly lies out, again, these two circumstances, and one of the circumstances says, or in connection with a filed criminal indictment or information, and there is no suggestion here that law enforcement can get arrest warrants absent this procedure.
Well, I'd just like to make a point on the first set of languages. And obviously it's not kind of directly addressing your argument, but I'd just like to make a good mention of it, that the overarching theme about this rule is that law enforcement officers have the ability to apply for warrants, and they're not debilitated from it. I think I think it's safe to say that we all agree on that. Rule 2 does allow them to be able to do that. As to the conditions for it is the issue that we're disputing here. And I see what point you are making as to the exigent circumstances, but I feel like you're really relying on the fact that they've waited 3 days before filing an affidavit. Seems completely bizarre to me. And your complete reliance on that seems troubling, because if I'm misunderstanding the legal standard for it, and happy to correct me if you wish, but I believe that exigent circumstances doesn't mean, that they would necessarily be, they would no longer be an exigent circumstance because, it's been some time and they decided not to. Even if they investigate it, it becomes futile because it's no longer a huge emergency or whatnot. The whole thing about it taking 3 days seems bizarre. They were investigating, as far as I'm concerned, and according to that affidavit, that they had investigated the whole situation. If, by your logic, that we would say that an affidavit where an arrest warrant is invalid because they took 3 days, which I assume they were probably investigating, well, likely not they will state that they're investigating, then they would have to file an arrest warrant only if, indeed, the incident happened on the same day at the very minute and second, and somehow they can't catch the guy, so they have to call us on the phone or whatever and be like, hey, judge, can I get a warrant? That doesn't make any sense, does it? I don't know. I think this is a little bizarre, and I might be misunderstanding this wholly. I may not be the most smartest person here, but I think it's a bizarre argument to make that an officer is expected to somehow sort this all out in 1 day or 1 second or 1 millisecond, simply because, simply because that's by your logic, that's how it should be. The 3 day thing is a little bizarre to me, and I've also had a read as to the fact that he was suppressed or whatnot. I believe killed, was it? He was shot and killed. Was that what you submitted? He was killed, and the result of that, there was no exigent circumstance? Is that what you said in your... No.
No,
What
I
was it
did
then?
say that the video that was uploaded with the affidavit does show that he was shot after firing the shots. And, Your Honor, the 3-day time period that I keep referencing, that is just part of the analysis for determining whether exigent circumstances exist. Based on a brief glance at case law, for exigent circumstances to sort of apply to the arrest warrant realm kind of seems a little bit unique to this game, because usually exigent circumstances relate to whether a law enforcement can do search and seizure. And so historically, when courts have been analyzing this exigent circumstance standard, they are looking at a now or never moment, because there has to be some reason, some pressing, concerning matter that kind of allows them to go around the normal venues, perhaps a DOJ investigation or criminal indictment. And so when I'm pointing that out here, Your Honor, I'm just trying to prove that this was not something that was immediately required given the circumstances. Again, there was a lengthy period of time. There was no threats to the public safety, no threats to the officers' lives, nothing of the sort that the affidavit
There was
had
no
pointed
threat to
out.
the public safety? There
No, the
wasn't?
affidavit did not point out the threat to the public safety. And again, Your Honor, I don't want to come up here and make rash or sort of conclusions, legal conclusions, based on this motion to quash. Right now, we are relying on what the affidavit had submitted.
Right.
Oh, 1 second, Your Honor. I think Tactical Pancakes needs to be brought back up to the stage.
I am trying to get him back in. I can't. I already requested him to be here, so he should be able to see it. I'm a little confused by what you've just said. What in the world? Sorry, I'm very lost by what you just said. Exigent circumstances don't exist because what on earth? What? Let's get back to this later. I think we're just going into some weird circular argument.
No, if you have any questions, I have no problem clarifying any confusion.
No, I'm just disturbed by what I'm hearing. I'd like to maybe get a little more time to think about that later. Perhaps we could go on to the other points about how this might be a procedural defect because of the leave to avoid arrest. That's what you mentioned earlier as well.
Yes, because again, this is what is outlined in the rules, Your Honor.
Yes, so you're saying that he hasn't actually... Hello, Mr. Pancakes. I'd like to have Bobby continue the argument here for the time being. We'll get back to you later here. Oh, actually after this, but hold on for a moment, Mr. Pancakes. So you're saying that he has not left to avoid arrest. At all. At any point.
No, Your Honor. No attempts based on the affidavit were made to arrest the original Tom Sheriff.
Right.
In these events.
Right. Okay. Okay. I'd like to make mention that in game there are particular people, usually those on a particular team, privileged of not being able to be physically restrained in any way, shape, or form. Otherwise, not really required to subject themselves to any form of arrest process whatsoever, unless they choose to. Are you saying that the leaving to avoid arrest condition is solely reliant on the fact that they have to physically leave the game in order for that condition to have been triggered? I just like you to clarify that.
No, the rules do. This rule says has left the immediate presence of law enforcement officers. So I'm assuming that could be evasion, or that could also be leaving the game physically.
Right. Okay.
Your Honor, can I make a point real quick, please?
Sure.
It sounds like the court is focused on elements of what the rules and relevant statutes and case law as they relate to what defines leaving to avoid arrest. And if that is the case, I would offer this is actually...
I've only just touched on this now.
Correct. Yeah. I'm sorry. I had a disconnection issue, so
that's fine.
Forgive me for that.
That's
the question
fine.
I would pose is that no effort was made directly following this encounter with LCPD for them to attempt to effect an arrest, and so for the then supposition to be...
What is that? What is the direct attempt to effect an arrest? What do you mean by that exactly?
Sure. As I was stating, leaving to avoid arrest, both in practice and by statute, implies that someone was actively trying to arrest you prior to you leaving. And there has been nothing supposed, both in that affidavit the court received or anywhere else in the factual aspects of this case, to suggest that LCPD was actively trying to arrest the client. And so because that is deficient, and I'm going to read a statute for the court.
Okay.
Under Title 5, 1801.4, arrest warrants may only be applied for during cases in which exigent circumstances exist and the person has left the immediate presence of law enforcement officers. In parentheses, the statute says LTAA. So unless the court is able to find somewhere in the affidavit that there is an allegation of the petitioner, sheriff, trying to leave to avoid arrest, the warrant is deficient on the very statutory grounds that are laid out before the court. So I guess I'm just a little bit confused why we're so hyper focused on this issue.
You may say that I am hyper focused on these issues, but I have a tendency to focus on these small issues, and I like to be thorough about it. There's nothing wrong with what I'm doing here. I think we can accept that. And if there is, God forbid, but I just want to have to mention that it is quite important for me to discuss these things because they affect your client's liberty in the future and potentially now. Besides that, I find that troubling, what you said, because if that were to be the case, then what about investigators? They can't apply for arrest warrants. How are they going to be able to?
Your Honor, the court is not the... Sorry, go ahead, Bob.
Sorry, excuse me.
No, it's fine.
Your Honor, if I'm understanding your question, you're asking if we believe that investigators can file for arrest warrants. And, Your Honor, I just want to circle back and say that we are focusing on this case here based on the affidavit and the information that we have.
Well,
Again,
I'm also doing that as well.
Yes, we are motioning to quash this particular arrest warrant. And so when
I get that.
We are focusing on who can do what and when can do what, we are looking at these rules in application of this warrant in particular. And
yes, but and I know that. I know what you're trying to do. I'm not doubting that whatsoever. I'm just questioning now because we've decided to do this hearing. Well, I decided it for a good reason, is that I want to actually hear these arguments and find out exactly what all your points were trying to what points you're trying to make. And I'm now hearing all these submissions that may seem outlandish or not. And if I just want to point out the relevance as to my question about the investigator stuff, for instance, the affiant themselves, as you'll both know, and I think the state as well, that he's an investigator. He is a detective, I believe. He is, for all intents and purposes, someone who would be working at a desk, doing some paperwork, looking at pictures, looking at video, collecting evidence, analyzing it, trying to connect the pieces. You know, an investigator, a police investigator, police detective. And they don't have, by your logic, any right,
Your Honor,
to apply for a warrant?
Respectfully, it's not our logic, it's the law. And again, I'm just going to point to this. The court has the right to review the law, but I don't think it's proper for the court to take offense with how the law is written. It's not our job.
I'm not taking offense to how the law is written at all. I am not saying that.
Can I finish my record real quick, please? Just finish my thought.
Yes.
Just several things. Just what I'm hearing right now is that the court is taking issue with several elements of our arguments. But all of our arguments are derived explicitly, word for word, from statutes. And that is the basis of our motion to quash. I mean, the very fact of the matter is, the state code requires that in order, and again, I can read it again, but I'm not going to read it again if the court doesn't want to. The state code is clear. Unless you left to avoid arrest, it is not proper to file for an arrest warrant. You're supposed to seek out other ways. And if the state legislature thought fit to change the state code, then they would be well empowered to do so, but they have not. This is the statutory language the court has to work for, and that should be the basis of their review, not this element of, well, this investigator should have been able to do this. Again, that also circles back to the fact that we have argued at length that the Lander City Police Department did not have jurisdiction to file in this matter for multiple reasons. Number one, because they lack jurisdiction, but even more so because they don't allege an LTAA occurred, which is the standard set by law. So for those reasons, again, I can't, and again, this is out of the utmost respect, but the court is hyper, again, forgive my words, but like it appears very, very focused on these constraints or supposed constraints on what you believe to be the need for good police work, or the ability for law enforcement officers to do their jobs, which is not.
Did the officers have the ability to really do their job in this case?
Well, Your Honor, the proper procedure for this, which is laid out in the state code, there's this wonderful agency called the Mayflower Bureau of Investigation, or the Department of Justice, or any number of agencies who actually have jurisdiction. If they felt...
No, I get that. I get that they can also do this job as well. But I feel like somehow, for some reason, the affiant, or generally the agency in which the affiant works for, is expected to somehow effectuate an arrest. But under the circumstances that they were in, I don't know if that was possible. Was it possible? Is it something I'm not aware about?
Was it possible for, in that moment, for
to arrest
CPD,
them, to restrain them, to tackle and restrain them in any way, stop further harm from being committed, other than having to resort to lethal force? Is there anything that they could have done to be able to do that?
Well, respectfully, they're dead, so we don't really know what they would have done. But again, in actuality, to answer your question, I'm sorry, that was a little bit of a joke. But in actuality, again, that I believe the court is taking the time to evaluate many different what-if scenarios that are not, applicable. And as the Attorney General is pointing out to me,
I don't know about this. I don't know about that.
Again, if you would just allow me to finish a record.
Okay, fine.
As I'm being pointed out to right now, which is kind of part of the joke I was making, the answer is no. Those officers would not have been able to effect an arrest because there's this thing called New Life Rule, which is they cannot enforce crimes committed against them when they have died, or vice versa when a criminal has died. And again, I just think the court is creating about a million different what-if scenarios of what could have been, what should have been, or how they think it should have taken place. And again, out of complete respect for the court, these are not the aspects of the case that are relevant to be litigated. The only thing relevant in this particular hearing, this fact-finding hearing, is the three prongs stipulated in our motion are applicable in this matter. It is not to litigate the factual allegations superseding the legal requirements. The only factual allegation that must be determined by this court is, in the first case, was an LTAA in progress, and that is not stipulated in the affidavit. The affiant did not say anywhere in their affidavit that an LTAA occurred, full stop. And the state code is explicit. If an LTAA is not present, then you cannot have a warrant granted. It's irregardless of the court's views or beliefs on what they should be allowed to do or what they are not allowed to do. It is the job of the legislature to change that. If the court feels that there is a problem, respectfully, again, with utmost respect, it's not the court's purview to do so. And I guess at this point, I think we're going in circles with an issue that is not to be litigated. The legislature left no room for it to be litigated, other than the fact that if an LTAA is not present or alleged, then there is no standing or justification to issue a warrant, and that's withstanding the other three what we would consider errors as to why it got granted. So, again, for those reasons, we would ask that the court quash this motion.
Right. Okay. I know that we still have to go over point 2, but I don't know whether you both would be wanting to raise that as another issue now, or if you guys would be deciding to drop that.
Well, if the court is willing to rule in the affirmative for our motion to quash, then I will be willing to stipulate that can be litigated at a later date if need be.
Whoa, hold on. What are you saying?
Exactly what I said. If the court is going to stipulate or affirm our motion to quash, then there's absolutely zero need for us to go to the second point, because the motion to quash would be moot at that point.
Because I ruled in your favor?
Your Honor, if the warrant is moot, then there is zero reason for proceedings to continue. And so what I was very clearly saying...
No, that's not what I'm trying to say, is that you're going to drop to point 2 being about my capacity and impartiality. You're going to drop that point if I rule in your favor. Is that what you just said?
Not no, dropping, choosing not to... No. We've been at this for over an hour now, and my point being that there's absolutely no reason to address another prong of our argument if, very frankly, you choose to deny. But I'll turn it over to Bob, and she can handle this. I don't think I'm being unclear at all.
No, I just wanted to clarify. I think what Tactical is trying to say here is that these three prongs that we are asserting in our motion to quash, they are not all three have to be satisfied. Only one of them, truthfully, has to be satisfied. And so I think what Tactical is trying to say is that if you find that any one of these prongs, 1 or 3, are satisfied, then there was no reason for us to go into prong 2 thoroughly.
Well, you raised the main part of your argument as well, and I understand out of interest of time that we had decided to come back to that at a later point during this hearing, but for some reason I've interpreted, or not interpreted, I've heard, at least in my understanding, that he would have, drop the impartiality argument if I had ruled in his favor, which I hope is not, in fact, what was actually said, because that in and of itself is appalling. So I'd like to ask you all, both actually, with a yes or no answer only. Did you say that point 2, being the impartiality argument and my capacity argument, was going to be dropped if I had ruled in favor of your motion, and I would have dropped the warrant?
Nobody made that suggestion whatsoever. And it's actually starting to get. Excuse me?
No, sorry, go ahead. I didn't mean to stop you there. My bad.
No one has made that argument. And very clearly, what we have said is that there would be no reason for us to go to another prong of our arguments in this hearing if the court would affirm our motion to quash. If you'd like to go into the second prong, congratulations, yes, absolutely. We will go to the second prong. The point we're making is that it would be irrelevant or unnecessary to do so. Not that we don't think those arguments aren't valid. We think the entirety of our motion is valid. We're saying that this has been going on for over an hour now, and I think we've established some very clear statutory authority to stipulate that our motion should be granted. And if the court has not determined so, sorry. Basically, if the court somehow, with both the first and third prong, has not somehow determined that it is proper for the motion to quash be granted, if that is somehow the case, then yes, we will go on to the second point and argue it at that stage as well. But I think we.
Well, you can't do that. This is your only opportunity, unless I order further hearings, and that would be out of respect for time. I've expected.
Your Honor.
Please, can I finish?
Mm-hmm.
Who was talking? Who's talking? That's a new voice.
This is the Attorney General, Your Honor.
Mr. Attorney General, I have your counsel here. Let him speak, please. Please. No.
I don't know that's how that works,
yes,
Your Honor, but I wonder if the court would...
Mr. Attorney General, I am warning you. I will make it very clear to everyone in this court. Anyone attempting to speak without the leave of the court will be held in contempt. This is an established rule. It does not matter whether someone's the Attorney General, the Solicitor General, the Deputy or Assistant Attorney General, a Chief State Attorney, or God himself. Anyone attempting to do this will be held in contempt of court. It is disrespectful to speak out of order and without the permission of the court. And it is going to disrupt proceedings and my train of thought in deciding a particular issue that could affect someone's personal liberties and their freedoms and their rights. I think we all have to be aware of that. Do I make myself very clear to all counsel right here, right now?
Yes, Your Honor.
Yes, Your Honor.
Yes. Yes, sir.
Lovely. Now let me finish. My God. Sorry, I was a little heated.
I'll take your point, Your Honor, and if you'd like us to address it, I'm going to address it right now in rapid fire succession. I will.
Sure, fine, please, because I expected you to finish all of these 3 points.
Yes,
and I will accept it for this purpose as the closing argument as well, once you wrap up your point 2, because I think point 1 and 3 you've already essentially closed those points. We've already moved on from them. So.
Sure. So if that's the case, then I will address point 2 and then wrap it all up. So
okay.
So one second, let me pull. All right. So the second prong of our argument was that you have a conflict of interest. I don't think this is a pretty outlandish supposition. I think this is pretty clearly established. You are a employee, a police officer of the Lander City Police Department since the 27th of February. The affidavit is filed on behalf of and in support of Lander City Police Department officers. The victims are alleged Lander City Police Department officers. So we're going to primarily touch on the code of conduct for state judges under Canon 3, which is disqualification, Section 1, some paragraph 3, which relies on that judges must disqualify themselves in proceedings that reasonably question the impartiality. I mean, I think Your Honor is intelligent. I think we can all agree that being employed by the very agency who was supposedly the victim and the affiant in a criminal case or a criminal matter, that alone is the image of potential improper and oh my gosh, excuse me, accents. Impropriety. That is a given. I don't think anybody, that is common law. I mean, like, very, very easily identifiable. You work for the very agency filing the affidavit to your chambers. I mean, I think that's a very clear conflict of interest. But you don't have to take my word for it. So as we stipulate in prong 2, for the judiciary to properly perform its function, justice must satisfy the appearance of justice. That's going to be cited in our filing with the court. This is not an appearance of justice. It appears, and again, Your Honor, this is not what we're alleging. This is what it appears. I think the layperson would agree that it appears that an employee of the Lander City Police Department, who happens to be a judge, signed a request for a warrant on behalf of a detective with the Lander City Police Department in regards to an incident involving 2 Lander City Police Department officers. I mean, that is the very image of potential impropriety, at very least. I mean, so as we list also in the Code of Judicial Canons for Conduct, not only does that appear to not be justice or not appear to be justified or proper, you don't have to take my word for it. Subparagraph 3 of Canon 1 for disqualification literally says, if the judge is a police officer employed in a police department wherein either the police department itself or a member thereof is a party to the proceeding, you must disqualify yourself. I mean, there is just the ample amounts of literature on this regarding when you should have disqualified yourself as a parent. And because the error exists, we're not suggesting that this was done maliciously or negligently. We're saying that an ample amount of literature exists to definitively say that the court should never at any point have been presiding over this warrant or request for warrant, excuse me. Canon 1, disqualification, subparagraph 3, you're an officer employed with the very department that is making the request. You cannot have presided over this case. And furthermore, as we cite in our filing under Anita Life Insurance Company v. Lavoie, that's a 1986 Supreme Court case, if there is an appearance of justice or appearance of lack of justice, the court must err on the side of caution. And Your Honor, I think, like I said, you're an intelligent person. Canon 3.3, subparagraph 3. I miscited. But, I mean, Your Honor, the court erred from the beginning when you presided over this matter. And because the error has happened procedurally, after you have issued the warrant itself becomes invalid because you failed to disqualify yourself when you should have. And so for many, many reasons, that is why we filed the the argument for prong number 2. And then just to wrap up, as you said, you wanted this to be our concluding arguments. It is well established before this court that, number 1, in order for a matter to have been brought regarding an arrest warrant, a request for an arrest warrant, the court must have some form of factual allegation relating to an LTAA. That is not my opinion. That is not what I request the court to interpret it as. Title 5, Section 1, 1801.4 says, without any room for question, that arrest warrants are only valid when they are applied for because someone has committed an LTAA. Nowhere in the entirety of the affidavit does the affiant suggest that this occurred. And the buck stops there. The court cannot proceed. The court should not have proceeded, and yet they still did. So in conjunction with the fact that the court had a glaring conflict of interest in this case, and the judicial canons prohibited the court in this matter from issuing a warrant, in addition to the fact that the state laws explicitly prohibit the issuing of a warrant unless an arrest, a LTAA, is alleged to have occurred. It is not proper for this warrant to have been issued in any regard at any stage. And for those reasons, the court should have and should now disregard the warrant in its entirety. And again, I believe I'm speaking well on behalf of the Department of Justice, who is not contesting the motion to quash. So for all of those reasons, and again, I know at one point the Attorney General wanted to make a record, and I would just ask that the court allow him that latitude. I think it would serve the interest of justice for the Attorney General to be allowed to make that record.
Right. As I'm concerned, the warrant is made under authority of applied by an authority of the state in many respects, and that this would essentially be pursued. Now, is it going to be? I don't know. But as far as I'm concerned, if the Attorney General is going to make a remark in favor of this motion, there would generally have to be a good reason, and I believe that counsel for the government here, Mr. Derogatory, is happy to do that on his behalf. Otherwise, make those submissions anyway. I'd just like to make that very clear that I can't really allow for the Attorney General to just somehow step into the bar of this court at any moment he pleases. And the way that he has conducted just now, I think it's very disrespectful to this court, and it was highly unappreciated.
I'll take your point on that. Yeah. Again, I would just ask, the Attorney General represents the entirety of the Department of Justice, including Mr. Derogatory. And just, he has indicated to me that he has some very important legal concerns regarding the affidavit itself in regards to its form and how it was submitted to the court. And he has specific subject matter information that is highly relevant to proceedings. And Mr.
Is he intending to make those submissions?
I'm sorry, I didn't catch that part.
How do you even know? Is the Attorney General telling you this right now?
Of course, yes, sir. Absolutely.
What?
Direct messages, Your Honor.
Okay, sit down, please. I'm gonna have you all muted. We'll take a 5-minute break. I'm not allowing any of you to leave. We'll have a 5-minute break. Everyone get a water break or something.
Real quick, you said concerned. We can't leave. I'm at work right now. I'm a firefighter.
Oh well, I guess. Okay. Well, in that case, I
don't think you can. Because I can't just tell.
Take a 5-minute break. Have a water break. We'll be back in 5, everyone. Thank you. We'll call recess for 5 minutes.
This motherfucker is fucking guilty.
In the interest of time, I will reduce it to 4 minutes. So we'll be here very shortly. Thank you, everyone.
All right, so what you got left for us?
I think
We're
he's
in
still
recess.
gone for another. Yeah.
Oh, forgive me.
Can we talk in here, or is this like the timeout corner?
I'm afraid it is. You can all converse among yourselves privately, but we're on the stage. We're an open court. We would like to have this muted for the time being. You may converse each other in DMs through messages. There's nothing wrong with that, but just not talk here until I say so. Thank you.
You got it, boss.
Thank you. Everyone, I'd like to bring everyone's attention back. Get everyone have their mics muted or unmuted depending on whether you speak. I think we'll finish on point 2 there. I don't think there's any further points to make. I think you've already wanted to conclude there anyway. If that's correct? No further comments
Yeah, that's
to make?
all I got.
Okay.
Unless somebody else has something.
The government would like to...
Yes, just state, please.
Alright, so the affidavit that was submitted to the court is improperly sworn with respect to, like, the affidavit actually being submitted by a different person other than the affiant. It was not intended to be submitted at all the time that it was. So this was purely a miscommunication internally. With respect to jurisdiction, yeah, it was a bit of a miscommunication inside of LPD. I guess somebody submitted the affiant's application for a search warrant on behalf of him, and it was not intended to be submitted yet. And so,
Yet? You mean they were going to eventually?
I'm not entirely sure, but from what I understand, there was an end goal, but it just was not... It was submitted prematurely by somebody other than the affiant. And so we had a bit of a problem there. And ended up being accepted, I believe.
Right, so if you're going to eventually submit it, you do intend to pursue the charges eventually? Is there a reason why it couldn't have been submitted sooner?
We intend to not pursue any of this after this. We don't intend to file any information with respect to the charges because we believe this was a big injustice.
Injustice?
Yes. Yeah, we do not support the warrant at all.
I'd like to ask what the reasons are to support the basis for this injustice being committed.
Yes.
Oh, notwithstanding the the points
Your
made
Honor,
by
are
the
you
motion.
assuming guilt without a finding?
I am not assuming guilt, no. I am just simply inquiring as to why the Justice Department is not pursuing charges after a warrant has essentially been submitted and filed. I just want to pry the facts just to be sure that there is a solid reason for them to make this in the public interest, but I don't think there's anything wrong with the court having to inquire about. Unless there is, please. But I don't think there is.
Okay, so
Yes.
pretty much I'm not entirely sure because again this is a big miscommunication as I said earlier. So we're not entirely sure whether the Leonard Police Department was requesting the warrant on their own accord with some sort of LTAA exemption to the warrant requirement. That makes no sense, but you get what I'm saying.
So you're saying the injustice because of a procedural issue?
Well, we agree with point one of the petitioner's arguments that there was no LTA or exigency.
Right.
We actually think that the exigency and the LTA work together, so that exigency cannot stand alone as a reason to request the warrant, but that it works in hand with LTAA. So there needs to be not only LTA but also an exigent circumstance to support warrant, and that just did not exist here. So we do not believe that the warrant was proper, and so it should be dismissed.
But what about the charges? You say you're not going to pursue charges. You may decide to not pursue the warrant. Sorry, not pursue the warrant. To have the warrant cancelled, essentially. And the reason for not pursuing the charges seem to be, I assume, it has to be different. Those would probably have a level of public interest at stake, and I would like to know the reasons why for that decision in particular.
Can I chime in real quick, Your Honor?
No. No. Please. It's the state's turn. Thank you. Mr. Derogatory.
Yeah. So, so you're asking, just to clarify, you're asking me why we aren't pursuing charges.
Yes.
Okay. So
I'm just curious. That's all.
Got it. So we're not pursuing charges just because we don't believe that the petitioner should be subjected to charges like this after something like this has happened. He's been somewhat deprived of liberty on accident as an error from the state, and so we believe that this is a remedy similar to, for example, a court dismissing something with prejudice because of a rights violation. This kind of thing is what we strive to do. We don't really intend to work off of injustice, if that makes sense.
I don't really follow what you're trying to say. It's confusing.
All right. What?
Could I chime in? I could possibly clarify.
But wait. But hold on. Why are you trying to keep clarifying this? You're not speaking for the government. What's going on?
Well, we have similar.
I am the government, Your Honor. We're the state.
I get that you are attorneys from the military to represent a fellow guardsman. I get that, but I'd like to speak to the pure capacity that we're dealing with here, so that I recognize you as defense counsel. I expect that there will be opposing points made, unless you are speaking on behalf of the government here. These are government submissions. I'd like to hear from the government.
I'm the government.
Orange Bear is the government, and please, no talk.
Sorry, Your Honor.
Thank you, Orange Bear. Thank you, government. Thank
Your
you.
Honor,
Yes.
you said that you did not follow, and I was offering. I am able to comprehend what the state is saying, and I was just trying to potentially offer it in a different set of words, so that you could comprehend what they were saying. And if you would allow me, I think it would just serve
If the
interest
state's
of
happy
time.
with that, if the state's happy with that, with the clarity, sure.
No, I'm pleased.
Okay, fine. Go ahead.
Yes, Your Honor. So, as you're well aware, the state has the discretion on which charges and whom they try to prosecute or who they choose to. And in this case, we don't think that this question is necessarily relevant. What I will say is that we understand that what they are offering to the court is that the state evaluated the elements of this matter and determined that they were not going to file charges. And that review of their decision-making process is not up for the court to evaluate. In fact, I don't think it would be proper for the court to interpose into something like that decision-making process, because I frankly believe that it would, number one, call into question the independence of the judiciary from the executive. That would be number one. Number two, it would call into question the ability of the Department of Justice to make decisions about how they will prosecute and the direction of justice that they will pursue, because the court then is making them justify their decisions, and they don't have to. And so, for those reasons, I would argue that, in addition to the fact that we completely agree with the state that there is a multitude of issues with both the affidavit and the issuance in general, we completely are on the same page with what they are offering, which being that there just lacks standing for this to have been issued. And again, as I will iterate, that the point I was making was that it should not have been evaluated. The process used to determine that they will not file charges, that is not, very respectfully, that is not the purview for the court to decide. I believe, and that's a little bit of what the state is trying to get at.
Right. Okay. Well, that's a better way to put it. I assume that's what you meant, derogatory.
Yes, Your Honor.
Okay. Okay. I'm aware of time as well, but I'd like to maybe gather my thoughts here for a little bit. If that's okay with councils, the councilors here, perhaps we could take, how does a 10-minute recess sound? I'd like to determine whether I should reserve judgment until such later time, or if I should decide to hand down any oral decisions now. Sorry, after 10 minutes. And see where we go from there. Would that be okay with everyone?
Yes, Your Honor. But we
Okay.
would prefer, if you are so inclined, a oral ruling on this matter, given that the arrest warrant still is in effect.
I understand, but that's why I'm considering the options. So I'd like to reserve, so to take 10 minutes to perhaps look into my options as well and consider the legal arguments. I do tend to make rulings at a lengthy amount of time, but they tend to be for a good reason. So I think we'll take a 10-minute recess here, and then from this point onwards, I think we'll probably get an answer for all of you here. Yes?
Yep.
Okay, grand. Okay, we'll take a 10-minute break, everyone. Thank you.
Alrighty.
So, how has everybody's day been?
Oh, fantastic. What about yourself?
Oh, it's been phenomenal.
Great.
Very busy.
Felt that.
Lots of calls?
Only a couple.
I'd like to bring everyone's attention for a moment, please.
Yep.
I've now been
You have
made
my
aware
full
as to...
attention.
Thank you. Councillors, please mute your microphones. I will not allow you to all to speak at this time. I'm only making an announcement. I have been made aware as to certain comments made by the Attorney General in regards to the current proceedings. and by previous conduct earlier as to his disruption, I have good reason now to order. To make a decision now and to order the Attorney General of this time on a separate matter to show cause as to why I should not be holding him in contempt of court. Let me finish. Thank you. And I believe that the comments that you've made in regards to this proceeding, which was in reference to my troubled or difficulty understanding the state's argument, was made in complete mockery and complete disrespect of the court's authority and the respect that it deserves, and also by previous attempts at having to speak on behalf of the state without my leave. I think I now have justification to have him appear before me on a separate matter, a separate date, or sooner, as to why I should not be holding him in contempt. I will enter a separate order in regards to that at the conclusion of these hearings. Thank you. We'll continue with our
order be written.
Yes, it will be. I will, of course, have it written. I never really just give these orders orally and leave it at that. I really never do that. So I will have it written, and it will be on the record for everyone. And for the benefit
Just to clarify, is he showing cause for comments made publicly in a public forum, or some other thing that I'm not aware of?
I believe,
because I believe his First Amendment rights extend to #general of the Clark County State of Mayflower District.
So you know about this. Well, I would hold him to show. I would still want to have him to appear before me and show why I should not be holding in contempt. That's only one of the reasons. It may be dismissed, but I will still have another ground to work with, which is that he has attempted to speak out of order.
I look forward to seeing how one can commit contentious conduct in a public forum. But I welcome your order, and I cannot wait to see how one can do so.
Mr. Pancakes, I think we've had enough. Thank you. We've heard enough.
Absolutely, Your Honor.
We will proceed. We will proceed to our recess.
How much longer?
We have approximately 8 minutes for your benefit.
Back.
Huh?
No, not you. The other one. Tactical.
What's up?
Yes, ma'am.
He's deafened. That means we can yap in here, right?
Ma'am, are you trying to get a show cause order issued against us?
I'm gonna bring up my translator.
Yeah, what's up?
Okay,
I'm the translator.
Why is the governor in the courtroom?
What's up, guys? I'm the translator.
He's the translator.
Hey, free my the Attorney General Nas Feelings, gang. Free him, free my boy Nas Feelings, bro. Hey, free him, bro. He didn't do nothing wrong.
You said 10 minutes, 15 minutes ago.
He's preparing something very, very lengthy. Please give him time. You cannot rush genius, okay?
You can't eat. You're a journalist.
Your Honor, you said 10 minutes like 20 minutes ago.
Well, still have a minute left. And also, I get what you were trying to say there, but please. I'm old. Very disrespectful.
I'm sorry, what's disrespectful?
The fact that you think that I am not really keeping track of time, for whatever reason at this point. 10 minutes, 20 minutes.
I would never doubt your ability to keep time, Your Honor. I think you are more than capable of doing so. I was just saying that I don't tend to participate in Lego hearings that last 2 hours, so I was just hoping we would kind of wrap this thing
we're
up.
here
But,
now, aren't we?
I am very confident in your ability to keep time.
Grand, thank you. Okay, I'd like to bring everyone's attention now. Just to make sure that everyone's here, can I have all counsel respond?
Yes.
Yes.
Present, Your Honor.
No, lovely. And Mr. Pancakes?
Yeah, I think I got covered up by somebody. I'm here.
Oh,
Your
okay.
Honor. Somebody blew up your car.
Oh, it's fine. It can always be repurchased. Great insurance in the state. Well, I'd like to now address my point. Perhaps. I will provide 4 reasons later in writing, as I would need to do so for the decisions that I'm about to make. On the motion to quash, and actually, before I do that, please, no questions. We will conclude it here since we've been here for some time now. We can reserve the questions at a much later date. But for now, on the motion to... God forbid, God, sorry, there's an explosion nearby. On the motion to...
Sir, please don't take the Lord's name in vain.
On the motion to quash, I believe that it would be not appropriate to grant it. And so on this occasion I will be denying the motion to quash. My reasons will be in full and in writing, hopefully very soon.
I'm
Can
sorry,
I
did you
please
say
have you
denied?
all... Yes. Is that a concern?
Yeah, a little bit.
I'm sorry, I didn't hear you. Did you say denied?
Yes.
Oh, wow.
Okay. Can I continue, please?
Absolutely, sir. You go right ahead.
I've been holding my patience with a lot of the shenanigans in the background. My head does hurt a little bit. There's a lot of noise. Understand that, please. You may not be able to hear it in my stream, but whatever. So on the occasion, I have decided to deny the motion to quash. As a result of that, the warrant is still active, and I will still compel for Mr. Sheriff Tom to still appear before a court or be arrested in order for his warrant to be essentially cancelled. I have some concerns as to impropriety. Strong concerns, in fact. Based on the conduct thus far between... Correct me if I say that. I'd like to just refer it simply as defense counsel and the state's counsel, government counsel. The fact that the Attorney General and both of you and the Attorney General are talking about this particular... both Mr. Pancakes and the Attorney General, talking about the particular case, whom he represents as government. The Attorney General represents the government. And I have reason to believe, and I will be inquiring this now actually, I have here some concerning news as to Mr. Sheriff Tom's MNG investigation.
Your Honor, are you saying you were involved in ex parte information during the
There is no
course of this?
This is a public record. These are news articles. I'd like to
So
inquire.
you're allowing the public record to influence your ruling on a motion to quash?
I am not saying that.
That's not proper.
That's a separate matter.
Correct, Your Honor. It's a separate matter that can't be brought up.
This is a concern that I have to raise now, whenever I have the opportunity, with the state.
Just so I'm clear, maybe I'm confused. Just so I'm clear, you took the public record and used it in order to justify the ruling of a motion to quash.
No, that's not what I did. You're mischaracterizing what I said. Those are not the reasons why I decided to do that. Now let me finish, please. Because I haven't even made any conclusions about it. God forbid I do. I am to inquire about this. It is a matter of public record that this news article, what I see here, has come on, and I would just like some assurances. Is that too much to ask? I don't think so.
A little bit.
Is it? I will ask then. Just to the state only, and if both of you are going to talk again without my permission, I will hold both of you in contempt. Please don't talk. I am going to take control of this now, because I am now extremely concerned for the following reason. As to how this whole affair is going. I have been suspicious by the fact that there were discussions between the Attorney General and Tom's defense counsel about this case. There is an article out, which I would like to ask the state to clarify as to the nature of it, if they're even aware of it. This article, titled "The Original Sheriff Tom's MNG Investigation Finds Severe Misuse of Force in Controversial MNG Shooting Later Covered Up." Are you aware of this information at all?
Who are you asking?
Yeah, who are you asking?
The state. Sorry, I'd like to clarify this, yes.
The state is not aware of the information, and honestly, we think it's a bit immaterial to the proceedings.
Is it?
Yeah, absolutely it is.
Your Honor, I was not aware of this article, and just can we clarify, when did you read this article? Did you read this article in support of your decision to deny the motion to quash? We just need to clarify the court record. This is
no, not at all. I've just found out about this now.
So you read it before you made your ruling, or after?
After. I never made a decision to deny this based on this article. I have no clue why you assume that. It's not relevant to the motion to quash. Yes, it is not.
It's very improper for a judge to read news articles while managing a case, especially when those news articles directly relate to the case. I mean, that is the appearance of impropriety.
That is the appearance.
Your Honor.
I have been suspicious for quite... Sorry, 1 second. I have been suspicious for quite some time now as to the way that these proceedings have been going. My trigger had begun from the moment that I've heard from you that you were in communication with the Attorney General about this. And
are we not allowed to talk to the Attorney General?
Well, the state's not even objecting to it, which I find surprising.
It's their prerogative if they object to a motion to show cause. It's literally the prerogative of the Department of Justice whether or not they choose to contest a petition. It's not the court's purview to say, well, this is just...
It's not, but it's just surprising. Because
so
the reasons for agreement...
Your legal justification is you have a really good feeling that the Department of Justice did something wrong. That's your justification.
You know what? I will say that I am not working off a gut feeling here. I am working off of credible suspicion of what's potentially impropriety. And I would like to be assured that that is not the case, because if there is, then we have a serious problem here. And I mean,
and it's based off a news article again?
I would like the state to clarify if they know about the contents of this and whether they could potentially look into the situation at all. That is what I'm going to be asking. Could I not do that? Is it improper for the court to be able to ensure that justice is fairly administered throughout from all aspects of the process? Can I not do that?
Your Honor, the law requires to be based on fact, and the court is saying that they believe, based on their good gut feeling, that something went wrong or something was done.
You're mischaracterizing what I'm trying to say here, and I can see it.
Well, Your Honor, we're just asking for evidence. Do you have any actual support?
I want to see whether there are facts to support it or not. It is just a concern. If I can't raise a concern in my own court, then what the hell am I doing here?
Well, usually concerns are based on facts.
Are you trying to say that I can't consider any of this because it wasn't formally submitted into evidence or whatnot?
Yes.
Yes. That's literally how the law works.
Provide me a procedural basis to support that argument whatsoever. Provide me a statutory obligation for me to be only. You can say hearsay if you wanted to. I am not asserting anything. I am simply asking the state whether they are aware of this, because it directly affects the matters of the case. Why this is even, I don't know, but it is extremely concerning.
Your Honor, I think this confusion on our end stems from the fact that we are looking at a motion to quash an arrest warrant, and we are looking at what the court was presented.
Yes, this is a separate.
At the time.
This is a separate matter.
We are looking at what the court was presented at the time. The arrest
Mr.
warrant.
Bobby, Miss Bobby, sorry. Please.
Did you just misgender my co-counsel?
I've said Miss Bobby, my mistake. I will correct myself there. But please, let me finish. I see your concern, but I have to assure you, and I will assure you, and this is the case, that I have not made a decision based off of a news article. I've only just found out about this now. It is a separate matter, which I have now moved on to, and I just want the state to clarify whether they're aware of it or not. Is that too much?
No, Your Honor. I just want to clarify, if this is a separate matter, then why is this part of your ruling on a motion to quash? Shouldn't this be addressed separately?
It's not a part of my matter to motion.
Then what's your basis to deny the motion to quash? Then what's your basis?
You will get my full reasons later.
Can you state a reason?
I cannot give you my full reasons orally.
Can you give a singular reason why our motion to quash was denied?
I am not going to give it right now.
Your Honor, I think
you're denying because you don't have a reason?
Okay, I've had enough. Stop talking. Mr. Pancakes, Miss Poppy, please. Let me ask my question, and let me finish this hearing. I want to move on. Please. You can challenge it in appeal. You can challenge it in some other way if you feel that is wrongly decided.
We don't know what your decision was. You won't tell us.
You will get your reasons, and then from there you can work from it. You don't have to find about it right now. Because the reasons are so detailed, and they have to be, to support any decision that I make. And I think it's warranted that it has to be detailed, considering, more likely than not, there probably will be some strong legal, and in fact complicated legal issues that it would still probably be facing to address. So please, let me get to that when I can. Is that fine?
Well, I don't have a good feeling about it. So if we're going off of feelings, then no.
Mr. Pancakes, I'm extremely concerned about how this is going.
I totally agree with the court.
Your Honor, I mean, it seemed like an open-ended question.
Do you want me to say why I'm extremely concerned? This is a separate matter to the motion to quash. This is not forming the basis of it. And please do not say that, because it's not true.
Well, Your Honor, I think we are all here waiting to hear why the motion to quash was, or is.
You'll get my reasons later.
So then what is
in
this
writing.
now?
This is not a ruling about anything related to the motion to quash.
So the
I am
court is
making
dismissed.
I haven't finished. You're not dismissed until I tell you're dismissed. You don't get to leave simply because I've just now finished and decided not to say it. You cannot
Sounds like
assume
this
that
is-
immediately. No, you're not. None of you are. Mr. Pancakes,
Oh,
I
Your Honor,
don't
since
appreciate
we're
the
not
laughing
dismissed,
either.
Can I have a bathroom break?
Sure.
I'm joking. I'm joking.
Right.
That's inappropriate. Don't joke with the court, please. Criminal.
All right. Just to get us back on track, I know we want to keep things smooth. Could we just, if you're not going to tell us why the motion was dismissed, can you just explain why you're using news articles to fuel your feelings as to what you believe or do not believe the state, or in this case, the Judge Advocate General's Court, committed an offense of some type? You've alluded to the fact that you believe an offense of some kind.
I have never stated this. What on earth are
You
you
just
talking
said
about?
you want to have a hearing.
Stop talking. I've had enough. I've had enough now. Stop talking. Both of you. Don't laugh. Stop talking. I am this close to holding every single one of you today in contempt. This is highly inappropriate. I am serious. I never hold people in contempt. I rarely, if ever do. This is like one of the rare occasions where I've even issued an order to show cause to the Attorney General. It's incredible. About a different particular matter. It's unprecedented what I've done here. And now... Actually, no, it probably isn't, but still. And now... I have extreme concerns, and I just want assurance. Or otherwise, just some clarification. I don't have a clue. I can overthink sometimes. It happens, we're all human. But this is extremely concerning. I just want to be
What's
sure.
extremely concerning?
Well, I will get to it if you allowed me to finish.
Your Honor, would you like the counselor gagged for the duration of your order?
Sorry? Who's this?
Would you like the counselor gagged? This is your bailiff.
Oh, sorry. Yes.
Alright.
Thank you. Sorry.
The counselor's been gagged.
That's our court security. If anyone doesn't know. I simply had enough with the charade. I am going to ask you the question, and I want you to be honest with me, Mr. Derogatory. And I will...
Yes.
And you can correct me, assure me, whatnot, if my suspicions are wrong, or my concerns are found on false grounds or anything like that. I am happy to be corrected about it. Please do so. But what I see at the moment from this is that there's probably some impropriety. I am being told dishonest things, maybe, or not. I don't want to be. I hope I am not. But this news article, a simple reference, and not putting it really on the record per se, so you can completely disregard it, and it will have no effect probably. But no, they kicked from experience. But I need you to assure me here, and I will make a reference to this article where it mentions about Mr. Sheriftom's disciplinary action. There is a MP report. Are you aware of this?
No, Your Honor.
You're not aware of this 1380325 CID report against Mr. Tom?
No, Your Honor.
You're not. Right.
Your Honor.
Yeah.
Could
Yeah,
we ungag Pancakes? He's getting a little uncomfortable.
No. What on earth?
Connor, can I ask you a question briefly?
That was funny.
That was funny. I haven't seemed to have received my warning. That's a little embarrassing. Besides that, I'll turn off that stream now. So you're not aware of that at all?
No, we are not.
Is there any reason why I should not think this is credible in any way, shape, or form?
Well, because it came from the media, I don't think this court should necessarily give it the same credence as if it were submitted in court. Same with something like hearsay from a witness. You know, an out-of-court statement wouldn't really make its way into court like this. I also don't really think it matters all too much, because I feel like for something to be considered impropriety, there needs to be some sort of regulation contravened. But here, I don't really think that's the case. The news is separate from the executive.
No, I'm not saying that the news is credible. I'm not asserting that whatsoever.
Right.
Your Honor, may I ask you a question briefly? Sorry to interrupt.
No.
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 I think we need to gag her
very
too, Your Honor.
relevant.
I will gag you if you do.
Yeah, please.
How's it
It's an
relevant?
American court, Your Honor. Respectfully.
This isn't a.
But
We're in
as a
Columbia.
JAG attorney, I think we have a direct interest in the CID or whatever military investigation you're referring to.
You do have a good point. Yes, I do agree with that, actually.
Yes.
Would you
And
be
so
willing
I
to
would like
clarify, perhaps?
Well, I would first like to ask, because I'm under the impression that all military documents, especially those produced by the CID, are at a very highly classified level. So I'm not
This is
sure
public.
where are you getting this from. This was not submitted to the court in any means for the support of the affidavit. So I'm confused as to why this is even an issue before this court.
Well, I have reason to believe now, but I will now say this belief that there is some sorry, I can't really pronounce it very well.
Is this an
Impiety.
investigation? Are we
I'm
being
not
investigated
investigating.
here, Your Honor? I'm confused as to why we are having to answer for these things when these have nothing to do with the motion to quash or the affidavit at hand. If there
But it
is
has
any
direct concern with the.
that
It has
is not
direct
the-
concern with the
This
defendant.
was not. Sorry, Your Honor. I don't mean to talk over you, but this was not an issue presented to this court, and I think it is very impractical for you to be raising this issue on your own, Your Honor. You're looking at what is presented to you.
I am restricted to my four corners in every case. Is that what you said?
Because that is what you based the.
I
arrest
moved on
upon.
from it.
It's not.
I moved on from
This is what we're
it.
here for, Your Honor. Is this
You want
what
me-
we're here for?
Do you want me to hold a different hearing for this particular matter? Then do you want me to make it
Yes,
official?
Your
then?
Honor. We are all here.
I am more than
We were
happy to
under
do
the
that.
impression that we are here for the motion to quash, and anything else is not relevant here, Your Honor.
Okay,
Again,
I am more than happy to do that then. I'm ordering show cause for the entire set of defense counsel here. You, Miss Bobby, and Mr. Tactical Pancakes, and I am ordering show cause for Mr. Derogatory Heroes on behalf of the state.
Show cause for what?
As to why I should not be
Your Honor, can I
issuing
take the tape off my mouth? Am I allowed to?
No!
Can you gag him again? I'm trying to hear. What were you saying, Your Honor?
Let me finish. Thank you. If Ms. Foppy insists that we should hold a separate hearing for this particular matter to raise concern validly, I agree. I think we should do that. I think that's a proper way to do it. Then we'll do it.
Yeah.
I will be ordering show cause to you, Mr. Derogatory, to Ms. Bobby, to Mr. Tactical Pancakes, of which Pancakes and Bobby are of JAG attorneys, who will be most qualified to answer some questions as to why I should not be issuing any orders. And I hate to do this. And I really do hate to do this. But I am seriously concerned.
Your Honor.
Any orders to prevent any form of impropriety and dishonest effort to suppress otherwise undermine the integrity and the administration of fair justice in relation to Mr. Sheriff Tom's case.
Your Honor, is this because the Department of Justice is not pressing charges? Because that's what it seems like.
No.
And this court...
I have concerns to believe that they are not pursuing charges, not because there is a public interest to not pursue it, but because there is some foul play. That is my belief right now. My reason and concern is that the state is intending not to pursue, not because there's no public interest, but because there is an actual concern for
that is
a dishonest
not
effort.
within the scope of the judiciary.
It absolutely is.
So, Your Honor,
It is an
are
inherent
you
authority of the
suggesting
court.
that from here on forward,
Do not
that
yell at
any
me.
time, I'm not yelling, Your Honor.
Yes, you did.
I
You
am
shouted
simply
at me.
asking
You
a
yelled at me.
question. Okay, Your Honor, I will move the mic.
Your Honor, would you like this
Is
woman
this tone
gagged?
appropriate?
Please.
Your Honor, please
This is
gag
not
her.
appropriate. I am accountable.
I have just
Yelling at
Had
gagged.
enough.
Yeah,
I've
Miss
simply had
Bowhead.
enough. I've simply had enough at this rate.
Can I have a chance to make a record? Yeah.
Yes. Fine.
I'm just concerned about like what the objective is with this order. What are you trying to like learn from us? I don't really understand like.
I want to learn whether the reason in which you are not pursuing the case is actually out of actual public interest, or whether because there is some foul play. I don't know what that foul play is, so I want to know. Because if there is a foul play here, then I am extremely concerned as to how the Department of Justice is actually conducting themselves in these prosecutions. It would be gross if I were to somehow, God forbid I even say this, and, restrain me or please. But I have extreme concern that the Department of Justice is selectively deciding not to prosecute out of not a public interest, but of a personal interest. That is very accusatory of me to say, and I don't even want to say it, but I am extremely concerned by this. Just because of the news article doesn't mean it, it can be entirely uncredible. It can be to some extent, maybe, but it won't be until we have some idea, some understanding, some facts to show that this is credible or not, or what have you. If anything, I need to figure out whether this whole thing did not even quash a warrant, Sorry, not even quash a warrant. That's not what I meant. What I meant to say was whether this whole prosecution against him or not was done actually out of the interest of justice. And I have a duty to do that. There is an inherent authority of this court to ensure that, to be able to do anything that it can to ensure the fair administration of justice is done. But where it does have jurisdiction over, which indeed this does, this case absolutely is something that falls in the jurisdiction of this court. All criminal cases get dealt with here first anyway.
Your Honor.
Yes.
Could you just give me a summary analysis of why you get to decide what the government will prosecute or not? Because respectfully, I do think you are misinterpreting your authority when it comes to actually administering justice. I think this is a bit extrajudicial where you're going with this.
Then you can make that argument at the separate proceeding.
Well, I don't think I should really have to, Your Honor.
No, you should.
I really believe
I am ordering you to show cause as to why I should not be issuing any further orders to prevent any form of impropriety in these proceedings. Because I am concerned that there is.
What order would come of this, though? Are you saying you're going to force us to bring charges? I don't really see how that would work.
We would explore options as to what we could do then. But this is not the time for it now, because according to Ms. Poppy, this is not the appropriate time to discuss those particulars. This is not the appropriate place to do it. We came here for one particular matter only, which is a motion to quash. And I agree with that. So we will hold a separate hearing for that matter at another time. Is that going to be an issue?
Yeah, it is. It is going to be an issue, Your Honor.
Okay.
Because this is insane.
It is insane. It is. I'm not undermining the insanity of what I'm doing or what I'm saying. But I am not entirely without justification here. I want to be without justification, so I don't have to take it any further, and then we move on from this.
There's no reason to. Okay. It would be one thing if we were prosecuting him with some other ulterior reason, but we're not charging him. There's no injustice being done here. That's the problem.
I am extremely troubled by what you just said. I hope you understand that.
About what?
What you've just said.
What part are you?
All of
not.
All of it.
It would be something you could look into if this were a criminal information filed by the government. But this isn't even a criminal case. This is a warrant application we're talking about here. And
for a criminal charge.
no, yeah, but it wasn't filed for information. It was filed for LTAA, which, I mean, it was filed prematurely anyway, and the government conceded that yes, the application was filed improperly. So I don't really know why we're even denying the motion to quash in general. The state erred, absolutely. So I don't really know what's going on.
The state erred.
Yes.
Were you actually involved in the process of this
You mean
affidavit?
was I actually involved?
Not you personally, but I meant the DOJ, for instance.
The
Were they actually
DOJ
involved?
was not involved in crafting the warrant, no.
Was it ever involved in any part of the warrant?
As in what? Like, approving it?
Approving it, signing it, whatnot?
Well, so what happened was when the LPD was like preparing the application, they put a placeholder signature from the prosecutor who was dealing with the LPD, Zolas, right?
I'm gonna stop you there. I think that's because I'm aware that the Attorney General had announced that he would do some LPD investigation or whatnot, and I feel what you've just said would be tackling that particular issue. Unless
it's certainly
it's,
not. It's relevant.
It's not. So we're not going to impede any investigation. As long as it doesn't impede the investigation that the DOJ is doing, then fine.
It's relevant to the particulars here. So the LPD put a placeholder signature there. Then Zolas was, he went to sleep. He was going to review that in the morning. So he had not yet approved it, but it was submitted, and it was just lingering on the document, the signature, and so somebody else submitted it for the affiant. So that caused a big issue, right? And then the court approved it, but that was improper, and with no LTA, no exigency. This warrant should not have been approved at all, and I think the court is kind of over considering the issues here.
So you're saying that I should ignore, otherwise not look into into anything further about this issue at all?
I think the issues really don't need to go any further than the basis of Rule 2. Because the rules of this court, Rule 2 of the rules of this court, specifically tackle the issues of LTA and exigency with respect to filing warrants, as well as information. There was no information. There was no LTAA. And I mean,
I understand your concerns. I understand the submission that you just made there. I understand it all. And I will give my full reasons to object to these. I will. Because I've denied it anyway. I can't consider these anyway. But I do understand the concerns that you have. I have recognized it. I have taken into account. I've already taken into account from the moment that we finished. I will give my full reasons. And I am also in an extremely uncomfortable position if I even have to raise these concerns. But I have to. I cannot just sit around here and somehow expect things to all work out or things to be fine or whatnot when this is probably not fine. I just want to be sure that there is proper justice. This is not about the Quash, this is about something else, the impropriety stuff. I just want to be sure that justice is fully administered in that. And today I've done something completely unprecedented by having to do all of this. I will recognize that. It's extremely rare that this ever happens with anyone. And I understand the gravity and the weight of the decisions I have made just now and even before that. But I have strong authority and reason to do this. And whether they are false or not, I don't know. I may have made a mistake in that regard, but I'm not going to be the one to judge it from now onwards. It will be out of my hands once I formulate the ruling fully in writing, and then it moves on. That is for higher courts to deal with. at a later date.
Yeah.
If that is to be the case. And that is well within anyone's rights. Of course, subject to the rules of appellate procedure, but nonetheless.
Have you considered that that maybe the reason this is unprecedented is because it's not allowed?
I don't know where you get the idea that it is just simply not allowed.
Well, I mean, usually when something has never ever been done before, probably because nobody, I don't know how to put this.
Or
Nobody
thinks
it for a
right.
reason.
Well,
I'm sure there's something.
What would the reason be? It could be because it's wrong. It's not correct. It's not right. It's banned. Or it could be that it's just never come up before.
Well, all of which are, I mean, I guess I don't really know. I mean, this is not.
I know
something that's within the court.
I think it extremely is. But once again, it's a novel issue in some respects. It may not be. I wouldn't know. But I would have to do my research to decide whether I should proceed with some of the decisions that I made. Not about the Quash, but about maybe the OSC that I've just given to all of you.
So you've done that without researching first?
I have, but I need to do further research, whether I am justified in having to proceed with the OSC's consequences. That is, whether I should give that order or not. I do have my basis to give an order to show cause at this time, and I will be requiring all three of you to appear at some point very soon about it. And if that's no concern, that's fine.
Well, I do have a concern. Could you just like explain why because you did say you have a basis for issuing the OSCs. Could you just explain why you are?
Impropriety. Foul play.
Foul play as in who? By who? The government?
Just give me a moment to kind of collect and say what I want to say. It's very hard for me to. Would you be willing to give me a minute?
Oh yeah, I'll give you a minute.
Good, thank you. Thank you, that's very appreciated.
Yeah.
I may or may not regret it later, and I hope I do regret it. Because I want to be proven wrong on this. Or shown wrong or whatnot, and I really hope I do.
Your Honor,
please, no. I think, after I finish this sentence, I think we'll just conclude it here. Okay?
Well,
I'm sorry.
I don't think this is the time to experiment, honestly. This is a very serious issue. I don't really think you should.
It is a very, and we are going to address a very serious issue, I believe. I'm not just going to say things and then just end it there and then move on with my life. Of course I'm going to look further into it, or I'm going to do this or that. I have a duty to. But I have extreme concern of collusion. Don't say anything.
Okay.
Reserve that for that hearing when I will schedule it. Please. It's better if we do it then. But I have extreme concerns of collusion. And I want to be proven wrong. I really hope I do. But there are extreme concerns of collusion, and I want to be sure that is not the case. So, the best I could do right now is for show cause. And that, I think, is wholly reasonable. It will give you the opportunity to assure me that it is completely unwarranted for me to have this feeling. Or that it is unwarranted for an investigation to happen into it, or whatnot. None of it. I hope that I'll be proven wrong on that. And that is the purpose for you to appear at that particular show cause. I just want to be proven wrong on that. If that is the case, then I will completely drop these concerns and move on, which I'm more than happy to do. But if there is a legitimate concern, and is shown more through that show cause, my hands will be forced. I don't know what you would expect in that regard then, but it's unprecedented what I've done. It's unprecedented on every level. But I have to do it. And I don't think...
Just a very small question. Like, I don't intend to, like, keep doing...
Any questions regarding why I'm doing that and stuff, please.
Just one simple question so I can kind of understand what I need to prepare for.
Okay, that's fine.
So you were saying that the state or some other person colluded with somebody else. I just want to understand who colluded with who. Did the state collude with the state?
That's what I'm trying to figure out, isn't it?
I guess.
I think that's the point of why I ordered a show cause. It's the best sort of process I have so far. I could do something else completely. I could. But by the gravity of what my concern is, I believe it would be more appropriate to consider the show cause. Now, if it's procedurally wrong, please correct me. If there's an alternative that is less, I guess, strong, but will achieve the same effect of... the same effect, the same outcome that I want, which is to figure out whether there is collusion or not, then I'm more than happy to consider that as an alternative too. But for the time being, I will be arranging for show cause.
When we do,
you can message me.
When we show cause, can it be in the same manner as we are right now, publicly?
If counsel is available.
All right, sweet.
I'm more than happy to do that.
Alright.
Ren. I understand that I've gagged Poppy and Tactical Pancakes, and I do sincerely apologize for that. But by the way in which both of you conducted just a bit now, I think it was warranted. I do not accept shouting, raising voices in this courthouse, in this room, anything like that. It's generally disrespectful too.
Yeah, both be... How do I... Both be? Yeah,
please, derogatory, please.
Sorry.
Let's mute your microphone, please. I'll finish my comments. No, please. Right. I understand that I've done something that I would not normally do either, which is to gag. But I have done it. If there were anything that they wanted to raise in regards to the concerns of collusion, this is reserved for their show cause. And that is the moment where you would do it. I do not appreciate what's happened here today. From the Attorney General having to intervene and speak, go beyond the bar and speak for the state without my leave, when he has not followed the proper process in regards to that, I felt concerned strongly. That should never be tolerated. The messages with the Attorney General in regards to this with Defense Counsel was very concerning. Why they would, I don't know. But along with that, plus what I've also had to see with the news article that I've just found out, containing a very credible looking document, and the state's intention to not prosecute for their reasons given, but which seemingly this document would show, potentially show otherwise, or what have you, raises extreme concerns as to why this hearing was even held in the first place, let alone why charges are not being brought against Tom is a good reason or not a good reason. I don't know. All of these concerns have serious implications for how justice is administered here, and it has to be done fairly and properly. I've done something unprecedented, and I don't think I'm going to deny that. The weight of what I've done is extreme. It would be something most judges would avoid doing, if almost.
Okay, never mind. I have access again.
But this is a novel and serious situation. One of extreme concern. One of extreme proportions. I would never have imagined this happening, or even the thought of it happening, or any of this happening in the first place. I never imagined any of it.
Your Honor.
And I want to be... No.
You're gonna want to hear this. I promise you.
No. If it's about what I'm going to say, please, reserve it for then.
It's not. Have you seen the news article by the Medford Gazette saying that you ruled in favor to quash the warrant? I think they need to show cause as well. It's in news.
Oh.
Despicable, honestly. I think so.
That's extremely concerning as well, but...
It is.
I think we'll have to address that later.
Can we bring them in now to address them?
Your Honor, wish to speak.
No, I think I'll just finish it here now. We've gone too far along. We need to move on at this point. This disrespect, combined with all of the information that I've just seen so far, and from the conduct of the council today, is extremely concerning. I have reason to believe on those reasons I have belief that a show cause is appropriate for all of you. And I would like truthful statements, truthful declarations by all of you as to what is happening.
Could the penalty for this be contempt, or
no? Most likely not. That would not achieve anything.
I would just like that to be set in the record before I.
No, I'm very unlikely to consider contempt on that unless something shows that there was a crime committed. Otherwise, there was such an egregious violation of whatever ethics or rules or even the law. That would still be a potential punishment, but if it is even a punishment, I don't know. We'll have to see, based on what the facts are about this whole case with Sheriff Tom. I think I've simply had enough today. I'm exhausted, I'm tired. On too much. I think it's time that we perhaps dismiss this now. Sorry, dismiss all of you now. And
I agree.
That we should perhaps look forward to further proceedings.
Can we ungag
yes.
Pancakes, both B and Orange Bear?
Yes, I think that. Oh
my God!
Both of you. Okay, well, no, I didn't realize that was what's
Your
gonna
Honor.
happen.
I will clarify.
I think you need to show cause.
Please. I've made my order on that.
It's a
Thank you, Your Honor. I'm sorry. I'm sorry. That you had the gag all the way to the back of my throat.
These are inappropriate comments to make in open
Very
court.
inappropriate, Your Honor. I so agree.
I'm sorry, Your Honor. It really hurt.
Your Honor, just before we go, this has really been everywhere. I just want to ask very plainly so that we have a complete picture. So, so you are denying our motion to quash.
Yes.
And violating my defendant's liberty.
No.
Based on some possibility of some collusion.
That is not what I said.
I think we need to gag her again.
No, she's raising a point, and I'm responding.
Oh, you're right.
Yes.
You're right.
Okay.
I am not
I guess
denying.
we look forward to reading
sorry.
your reasons, Your Honor.
Okay, that's fine, and you will read my reasons on that. And I am not basing my denial on the motion on the basis of that collusion. That is an entirely separate matter. This is for the motion to quash, and you have appropriately pointed out that this is only for that, and I agreed. And we will hold separate hearings for the matter of that collusion. I hope it isn't. Because if it is, I will be speechless. I'll be speechless.
Speechless.
Are you giving us written notice?
I wouldn't even know what to say. I hope
Honor,
that's not the case.
Could you just apologize to
getting
the
written notice?
pancakes and both B for choking them?
I have to apologize?
Yeah, just you kind of choked them out.
Your Honor, my throat hurts.
Everything hurts.
Freaky Judge.
Okay. All three of you go to my chambers immediately after this.
Is that the
Yes.
case, or
It will be.
another...
It will be in the. So if you look at my category, you guys don't have access. I will add you all
Then
to
order,
it.
Your Honor.
Yes, I am ordering you to appear in chambers. Well,
Your
all
Honor,
three of
I
you.
can't appear in chambers. I have stuff I gotta go do.
Yeah, I'm also a firefighter. We work in the same fire station, so.
Okay then.
Yeah, we're on the same fire engine.
Yeah.
I don't
we're actually
believe.
responding to a call right now.
I don't believe any of this.
No, he's not lying. I'm his chief.
Okay.
Yep.
I've had enough. I've tolerated this for quite a bit. This chicanery for, in reference, I guess, to the Better Call Saul show, but whatever.
Yo, he said the
show.
word, yo.
But I've had enough. I've simply had enough with the way council have been conducting themselves here. This is unprecedented. It's nothing. I am holding Mr. Pancakes, Boppy, Miss Boppy, Mr. Derogatory, in contempt of court.
Oh my god.
For your conduct today, and just now.
Thank you, Your Honor.
I will be requiring... What?
Then mute the judge.
Don't mute me, God. What the hell did that? Oh, Trev, please don't. I've had enough. I'm ordering contempt of court to all three of you at this time. It's simply enough. You will also all be appearing at the show cause regardless, as it is a separate matter, and I will enter orders in regards to that. Do you understand? All three of you. Oh,
It seems they've been gagged again.
Yes, I don't know why
I
they
think
were.
we understand, Your Honor.
Sorry,
Okay.
I can't breathe. I can't breathe.
Your Honor, I understand you'd like to see me in your chambers. What exactly are you going to do to me while I'm in your chambers?
That was inappropriate. Can we gag him again, Your Honor?
I'm not joking around here, just saying. I know
Neither
you're
am
all
I.
trading.
Sure, what is going on around
This
here?
is not a joke.
I am entirely
I don't
serious.
believe that you guys are taking this seriously at all.
Your Honor, I just like
I
to
realize
be
that I will
clear.
be-
I'm honored that
Can
you
we be
hold me in
dismissed?
contempt.
It's a privilege. It really is.
I've had enough. Okay.
You said that like an hour and a half ago.
Ooh. Wait, he just got kicked.
I don't know who kicked him, but that wasn't me.
All right.
Either
I
way,
do have to
I'm
go.
open.
I have real life responsibilities. So can we be dismissed?
You will return with a contempt of court penalty imposed on you. I will not do a show cause. It is a direct contempt. Direct civil contempt.
Civil.
I think we have a right.
Oh, alright, what did I say that?
Wait, so
Criminal
do we have
contempt.
to go to your chambers or not?
At this time, no. I don't think it's appropriate. But I'm gonna hold you, I'm sorry, direct criminal contempt.
Okay, if it's criminal, we do have a right to give the opportunity to show cause. I just hope you would afford that to us.
Do you wish to?
Yeah,
It's
like
our due process, right?
Please. We could just have the
It's
opportunity.
literally the constitutional right to have due process.
For direct criminal contempt?
Yes,
Yeah.
that's especially.
Unless you would like to make another unprecedented move, Your Honor.
Ooh.
Unprecedented.
Fine. Okay. I will do this then. And this will be now. I don't care if you have your obligations now. If you don't, too bad.
Sir,
But
I'm literally a firefighter.
I respect and commend you.
Me too.
I really do. I truly do. But I didn't come here to waste my own time.
Sir, I have to go clean the station.
Your Honor, someone's grandmother is
Right.
calling life support right now. Please.
Your Honor,
I'm ordering. Okay then,
line.
fine. I rescind my previous decision on the contempt. Instead, I will require you. I will order all of you, Miss Poppy, Ms. Tantual Pancakes, and Ms. Derogatory, show cause as to why contempt should not be given against all three of you. You will be given the opportunity to be heard. Notice will be given as to your offense and to the nature of it. You have a right to counsel if you wish to. You may represent yourselves if you wish to. You will be appearing immediately to the Supreme Court before a panel of judges who will be conducting the show cause hearing now. This is an order that you now have to follow. If you fail to appear before them on this matter, they may impose penalties, and you may also receive further penalties as a result of that as well. All three of you are understanding that. I do not care if you have current obligations right now. You usually do. What the hell? Oh, sorry, I don't know what happened there. I don't care what you have to say in regards to this. But I'm going to get you all the opportunity that you really want. Right. Also noted that you all three of you will appear for show cause for the collusion matter separately. I'll enter all of this in writing. There. All three of you are now discharged from this hearing, and apparently we will adjourn. Thank you, everyone.
Wait, where's the gavel noise?
Does anyone have it?
Bing, bing.
Alright. Thank you.
What was that?
Never in my life have I seen such